Welcome everyone, and thanks for taking time to attend this meeting. This meeting is a general purpose meeting to get a little bit more context and understanding on estate planning and asset protection. And I will begin with a disclaimer that this meeting is to share my personal experiences and opinions. I would welcome people to share theirs, ask questions, and I will try to clarify based on my own understanding. Any discussion within this meeting, whether in part or in full, cannot be taken as a professional advice. This is a kind of personal opinions and experience sharing forum, not for professional advice and something that can be actioned upon with reference to this meeting only. All right, so I will get started with a brief introduction about me, and I will welcome you all to subscribe to my YouTube channel if you have not already. So the purpose that I conduct these kind of meetings is because I'm passionate about uh, empowerment through education, and it's a sort of mission for me to achieve financial independence. With that, let me jump right into the content that we are talking about. So, jumping right in, estate planning and asset protection. These are the two big things that I'm going to talk about today. And what I'm showing is purely my perspective. So I believe estate planning is something that serves you while you are living, and it serves your family or your loved ones afterwards when you are no longer either no longer in the world or no longer in the position to take care of your family and loved ones. So I will go in a little bit more about what do I mean by this. And asset protection, my strategy is always be poor on paper. So contrasting to what a lot of people, particularly coming from Asian region, is instead of showing off wealth, I believe in kind of being poor on paper so that everybody recognizes me as poor, but rich in real. That is for me to enjoy my richness rather than others to either envy or probably talk about my wealth. So why are these two super important things in your own life and in your own family's context? There are so many reasons why you should be doing estate planning and why you should be doing asset protection. And this doesn't mean that you have to do these after maybe you are in your 40s or after you're probably having accumulated a good wealth. These are the things that I would say you should start immediately after you attain the age of 18 years. The sooner the better. Once you become certified adult, celebrate your 18th birthday, this is the first thing that you should start thinking about. Either you learn or you act, but don't delay. And if you have not done, then any time soon is good enough time. So there is no regret that you have not done it so far. If you have not done it so far, do it now. So why are these super important? I'll elaborate point by point in my next slide. And I will also cover in this session what are the exact tasks that are required to be done in both of these segments. And I am a personal believer that you can do a lot of these tasks in a DIY mode, do it yourself. Some tasks are simply that you need an intervention from the professional. So I'm not talking of professional advisor. I'm talking of professional who is responsible to execute those tasks. So a lot of people think that this is not a DIY space, but I believe that this is a DIY space. You delegate certain specific tasks to do, but more importantly, you need to understand the context. You need to understand what exactly you're getting into so that you can effectively delegate the appropriate tasks. So, coming to estate planning, and as I said, it serves you while living and it serves yours afterwards. So, let's go get into the context of why. So, think of scenarios, and estate planning means these five things that I list here. There may be more things that people might have done, but this is These are the 5 things that I have done for my family. So why do we need estate planning? So think of estate planning as that if you are incapacitated or you are no longer in this life, then whatever you have accomplished throughout your life, how to basically put that into use for your loved ones who are there after you. So if you're incapacitated, there may be decisions about you, there may be expenses on you, and since you are incapacitated, your own money may not be utilized. For example, let's say, God forbid, you get into an ICU for 3 months, 6 months kind of time period. Let's say if you are husband wife pair and both get into that situation. So while this is unfortunate to think and talk about, but this is probable. You get onto the road any day, you can get into an accident and you get into a situation where both husband and wife are in ICU. You have minor kids. First of all, who will decide that treatment plan you are comfortable to follow on your own? Who will decide what kind of expenses are to be done on your family, on you, and who has access to that money? You might have accumulated a lot of wealth, you might have accumulated a lot of other kind of assets, but ultimately, if you don't leave the proper instructions and if you don't leave a kind of organized structure around your wealth, it may be very, very difficult for your surviving loved ones or someone who can take care of you to kind of manage that thing. So these are very practical and real scenarios. So if you are incapacitated, you may be at a stage where you are, again, I'm sorry, but we have to speak that kind of language. Let's say you are on ventilator. You are in a situation where all medical opinion tells you that you are going to be on ventilator if you want to live, and there is no recovery possible from medical point of view. Now, it's a point of decision about you whether you want to continue to live on ventilator or you want to pull the plug. Who can take that decision? Since you are on ventilator, you cannot take that decision. Have you given the permission, the power to somebody else to take that decision on your behalf? So that's important. Similarly, there could be certain situations where you want to say that, okay, I don't want to get treated in, say, United States, or I do not want to get treated by a particular doctor. I do not want to get treated in this manner or that manner. So again, since you are incapacitated, nobody can take that decision, right? And you leave it at the mercy of somebody who claims to be your custodian. So anyway, these are some of the whys that why you should be doing estate planning. And the list that you see on the screen are the whats of estate planning. So what means? You need to be doing a living trust, you need to be doing a last will and testament, you need to create a general durable power of attorney, you need to create healthcare directives, and you need to create an authorization for disclosure of protected health information. So what are all these? I'll spend probably a minute on each to explain what do they mean, and then I will talk about how you can get it done. Living trust. A lot of people have heard this term, and this is probably most commonly talked about term, and people get into this and then get confused, like, do I really need it or not? So in my opinion, a living trust is just like a treasure chest. A treasure chest which comes with its own manual of operations. So it's a treasure chest that you cannot operate without reading the associated manual. And what is inside the treasure chest? So whatever you wish to put into that treasure chest is your choice. You put those things into the treasure chest, and after you are gone, anybody who you have appointed and you have given that manual, that person is going to operate the treasure chest, chest and distribute the treasure inside to the people that you have identified. During your life, you can, at your own will, either keep or remove items or add items into that treasure chest. You can probably destroy that treasure chest. You can appoint some other person as a kind of caretaker of that treasure chest, but it's a treasure chest. You basically put items that you want after you are gone to be taken away and distributed as per your wish. So living trust basically is having two associated documents. One is called the certificate of living trust, and another is called the operating agreement or the agreement of the trust. Certificate tells who created this treasure chest. So, who is the settler grantor? Whose wealth is in the treasure chest? That is settler and grantor, and this is one key party. So, typically, it could be an individual or it could be a husband and wife couple. Then comes the trustee, who is the person who can operate this treasure chest by reading the operating agreement. So this could be any person that you appoint, has to be an adult, has to be someone who has the capability to operate based on the instruction recorded in the agreement. During your life, it is very common to appoint yourself as the operator. And once you are no longer there, you identify a successor operator. So this operator is called trustee. So during your lifetime, you operate as trustee, and you means you or husband and wife couple. And then after you are gone, if your kids are adult by that time, your kids can be the trustee, or you appoint somebody from your family if you trust them, or you appoint a professional or an institution to be the trustee. And then there are beneficiaries. So anybody who you think should get the share of the wealth inside the treasure chest, you identify those people as beneficiary. Typically, those beneficiaries are your kids. Now, again, unfortunate to talk about, but it is important. What if your kids are no longer before you are dead? So you define all those situations that after you, your spouse. After you and your spouse both are gone, then your kids. If there are no kids, who? All those things are written in the agreement of the trust. And certificate is only telling who are the settlers, who are the trustees, what is the role of the trustee, what is the limitations, powers, and things of the trustee, and all that. So, how do you create a living trust? So, while there is no licensed professional required to create a living trust, you can actually create it by yourself. But that doesn't mean that you have the uh, right knowledge to make it legally enforceable. So, for that purpose, there are so many online platforms which have state specific templates and very generic conditions which typically prevail in 80% household. You basically create those boilerplate standard living trust documents, and once you create those, you just need to get notarized signatures done for two witness and yourself on that, and you can get it done again on your own. A notary is involved definitely. Once you do that, you can actually get your documents reviewed by attorneys or banking people and all that, and they may basically provide you inputs that you might need to change. Otherwise, it's good. Again, creation of living trust itself, it's a private document. You can create yourself if you know enough. If you don't know enough, you can hire a professional advisor and all that. And then once you put that document into proper execution format, then you can basically get it reviewed afterwards as well. Similarly, last will and testament is again a document that has to be legally sound. but it doesn't need a lawyer to create. You can create on your own using any of the online portal, but ultimately it has to be legally sound. So the difference between living trust and a last will and testament is that while I defined living trust as a treasure chest which contains the treasure, last will and testament is a separate thing which is purely a set of instruction. It is not a treasure chest. It is a set of instruction to somebody that what to do for anything belonging to me, my assets, my liabilities, my funeral, my kid, everything. I'm telling as a set of instruction to somebody, and that somebody can execute those instructions on my behalf. This last will and testament in many states has a limit on what you can execute without interference from the government. Probably I am not a kind of financial license professional, so I cannot tell you, but some states have, like, if your net asset value is probably under $50,000, you can go without probate. But the last will and testament things are generally go through the probate process, and that's lengthy and that involves cost. So you create living trust for a purpose, and then you create last will and testament for another purpose. So most important aspect of last will and testament is if you have minor kids, who is going to be the guardian of that minor kid? So that's the key difference, that while living trust is a treasure chest, last will and testament is an instruction document. Then there is a general durable power of attorney, which means that if you are not in a position, or even if you are in a position but you want to give somebody else the kind of authority to decide on your behalf and act on your behalf. For example, you write checks from your checking account. With a person who you give the power of attorney, they can also write check on your behalf. They can withdraw money from your account. They can probably sell your house. They can do a lot of things if you have given them power of attorney. This is a dangerous instrument if you give it without restrictions to anybody. So you have to give it to somebody who you trust, and you have to limit what you are basically giving the powers to. And then it is required. It is very important because there would be situations when you may not be available to execute and you need somebody to be able to execute. For example, it could be that you want to sell off your house, and for some reason you are not available and your spouse cannot probably sell without your power of attorney. So a community property like a house, husband and wife both have to sign to sell. Now, if you have given to your spouse a power of attorney, your spouse will sign on her own behalf as well as on your behalf. And that's the kind of power of attorney purpose, that you, if you give it to somebody, they can act on your behalf. Healthcare directive is again durable power of attorney. Again, it has to be a legally sound document, and there are online platforms where you can get a boilerplate kind of template and customize and create your own. Again, create it with witness and probably notarize. Healthcare directive, again, it has multiple things, but it's a one single comprehensive document which talks about that related to your own healthcare. What are the instructions that you want to pre-give to somebody? So it includes power of attorney to act on behalf of you for healthcare matters. It tells about instructions about your treatment line. For example, I talked about if you want to pull the plug on you for being on ventilator too long, you can write that, okay, I don't want to be on ventilator beyond a reasonable period. If medical opinion is that I cannot recover, I would rather prefer to die. Similarly, you can write instructions about I want to donate this and this kind of organ to this and this body and all that. So all this is healthcare directive that you should create. And finally, authorization for disclosure of protected health information. People are aware that our regulations are prohibiting people to share healthcare information with anybody. Even your spouse cannot get access to your healthcare information if you don't authorize. And this becomes a stumbling block when you are incapacitated. So you should create one or more persons authorization for disclosure of your line of treatment or your health information so that they can take care of you and all that. So in summary, estate planning means that you are acting at least on these 5 points. You first research, understand the relevance, go into the nitty gritty. Either you get the knowledge through internet or consultations with financial advisors or discuss among your friends and peers, but build a good consolidated understanding of what does it mean, why you need it, what exact tasks are to be done, and then you get into the execution mode. If you don't feel comfortable, you appoint somebody who like a estate planning office, attorney office, or whoever, and they will create these documents for you. If you are confident enough, go use online platforms, create it yourself. Creation of a document by an attorney takes much more cost than just getting a review of your own created documents and getting a paid opinion. And you can get paid opinion from multiple attorneys and professionals. Again, choose your method of how you want to execute, but you can execute. And I'm telling you, the longest part is building your own understanding, and the shortest task is actually creation. So invest time to understand. So with that, I will move into the asset protection part. It First of all, remove from your mind the mental block that you need to worry about asset protection when you are a millionaire. No, even if you have probably $100,000 worth, you still need to start doing asset protection. So whatever asset you have, you can lose them very easily in this country through litigations and liabilities and all that. So you need to really act on your protecting your assets. So there are two broad strategies that I personally follow and I implement in my own family assets is I segment my assets into three categories. One, family assets, another, friendly assets, and third, fragile assets. I'll talk about what does it mean in a bit, and then kind of create specialized boxes for putting those assets into those boxes. And these specialized boxes are nothing but the right kind of legal entities who holds the asset. So asset generally can be held either by a person or by an entity. So I will talk about these entities in the context of these assets one by one. So family assets. Typically, these are the assets which are very, very personally connected to you. You are directly associated with it, and they can create a liability exposure for you. And many of these assets can be titled. That means they are registered, recorded in government books, and many of these assets can be untitled. And I'll just quickly give examples. For example, you have your car. Your car is recorded in government books in DMV and all. It's an asset, but it can also create liability for you. What if your car is in an accident? It can create a liability for you, and that's why you have to protect yourself from the asset, and you have to protect your asset as well. So if your car gets totaled, then you lose the asset, but your insurance probably will pay you back to protect the wealth associated with that asset. But if your car hits somebody and that somebody sues you, then not only your car but your other assets are at risk. That creates liability. So these are assets that typically you cannot detach it from yourself, but they are, while they are assets, they can create liability for you. And these assets, you can think of your automobiles, your primary home, your checking account, your jewelry, your IRA, your life insurance, and all that. So how do you protect these assets? So many of these assets are protected by their own specific insurance like auto and home, but some of the assets that cannot get protection by itself, you as a person or you as a household should take umbrella insurance for general liability protection. So this is called outside kind of attack. Because of certain other things going on in your life, if somebody sues you and comes after your assets, then your umbrella insurance acts as a shield to protect that asset from being liquidated and being given away to somebody else. So umbrella insurance is very, very important. And you as a person is both asset as well as liability, because your actions can create liability. But you as a kind of employed person, you generate income for your family. So you need to protect your actions that may result in liability by umbrella, and you protect your income by way of life insurance. So if you are no more for some reason, you should take a life insurance. A lot of people do mistake that your insurance is provided by your employer. That's true, but that's a limited value and it lapses as soon as your employment lapses. So before it's too late, in the young age, try to take a life insurance and invest that money not in IUL kind of products. Purely consider it as an insurance. Do not consider it as an investment. It is a life insurance which will probably have living benefits, as well as if you have untimely death or if you have probably incapacitation to some extent, your family can get some money out of it. Now, how do you put these assets into specialized containers so that these can also be protected? And some of those specialized containers are living trust, as I talked about previously, that living trust is a treasure chest. You put things into a living trust. So, for example, you put your primary home in living trust. You put maybe some other assets in your living trust. Then there is a specialized trust that can work for some. It may not work for all. QPRT. It's a qualified personal residence trust. So it has some tax advantages, it has some other nuances, very complicated, but if it is something that may work for your family, you put your primary home in a QPRT, which is Qualified Primary Residence Trust. And then your IRA, solo 401k, these are retirement trusts. Nobody can take away your money which is parked in IRA or 401k. Any kind of liability created by you, if your creditors come after, your IRA 401k funds are protected, right? So now let's move quickly on to friendly assets. So these are the assets which are your long-term holdings, and you are not consuming these on day-to-day basis, and you can afford to keep them at a distance. People from India generally are very familiar with putting their gold and other valuables in bank lockers. So this is that kind of friendly asset. In this country, they cannot create a liability for you. If you hold stocks of a company, if you invest in a syndication, if you invest in crypto, if you invest in high yield savings accounts or other government bonds, these cannot create a liability because you are holding them. You That doesn't create liability for you, but these assets itself are at risk, because if your actions are creating a liability, then somebody will sue you and get hold of these assets. So, how do you protect these long term assets? You basically segregate them from yourself and you put them into a separate entity which is protected. So, you mean that what I did and what I'm suggesting here is that never hold a savings account in your own name if you do not intend to use that fund in next 3 months, 6 months kind of timeline. Never hold stocks and bonds in your own name if these are for long term, right? Then how do you hold these? You hold them into a specialized holding entity where you can have a strong charging order protection. What does it mean? That if a creditor sues you successfully and they get a judgment to attach your assets, then they can attach your personal assets, but they cannot attach the assets that you have segregated and kept in an entity, and that entity could be a LLC. So if you have significant investments, then you park those investments in a LLC, and charging order protection is different in different states. So Wyoming is a state which gives you strong charging order protection. So I did my own parking of these assets into a Wyoming LLC. Wyoming, like, what is this charging order protection? Charging order protection is that you cannot attach the assets of the LLC. You cannot take away the LLC. The only thing that you can take away as a successful creditor is if the owner of the LLC takes money out of LLC as a distribution. And as long as you have a strong charging order protection, which is available in some of the states, and Wyoming is one of the most affordable state which offer this. So create LLC, park these things in that, and do whatever. And whenever you need money out of that bucket, you can, in all happy day scenarios, you can take money out. The moment you get into a litigation, don't take money out from that entity, because that money may be going to creditor rather than to you. Now, your assets locked in that entity doesn't mean that you do not have access to that asset, or your family do not have access to that asset. You can always have means and mechanism of accessing that. Rather than losing it to your creditor, you enjoy it in a concealed manner. Let me go to last segment, which is fragile assets. These are the assets which are very high liability exposure creation. So these assets can create very high liability for you. And in return, you may, as a kind of loser in a litigation, you may not lose only that particular asset, you may lose all of your asset. So what are these? Some of these assets: rental real estate. If you are putting a real estate for use by others, if you are putting the real estate for short term, long term leasing, or a commercial establishment is running in your real estate, so it could be a land, a parking lot, it could be a rental home, it could be a commercial establishment. As long as somebody is using it, it creates a liability. How it can create liability? For example, there is a land, and you think that you are simply doing nothing on that land and parking it for your future use. If somebody gets killed on that land for some reason, you may be a party to that litigation. If you own a parking lot and somebody get into some kind of accident, you may be a party to that liability. Again, any real estate which you are not using for your personal use and you are leasing it out or putting it into commercial use, that is generating income for you, that is an asset, but it also creates liability. Similarly, commercial tools, machineries, equipments, people who basically may be owning these big tools, machinery, and leasing them out, they are creating liabilities for them. Commercial vehicles, boats, and other things again being used by others can create liability. So there are inside out as well as outside in liabilities that can be created. Quickly explaining what is inside out: you own a single family rental property. Somebody gets into an accident on your property. That tenant or that person sues you. Then this is inside out liability, which is like it originated from that particular asset and it is affecting you. So that means that a single family home, probably let's say $200,000 worth, has created a liability for you where your net worth is $5 million. So a $200,000 asset is creating a liability and a risk for your $5 million wealth. That is inside out. Outside in, you have a $200,000 home, and that home is running well and giving you cash flow, and you are enjoying that. One of your action uh, triggers the litigation, and all of your wealth is at risk, including that $200,000 dollar home, which did not create anything wrong for you, but it's a outside in kind of risk for that. So there is a protection strategy for both. You need to quarantine each of these assets from each other, and you need to kind of box them separately so that contamination happening in one asset doesn't affect the contamination in other asset, and contamination originating from outside doesn't percolate into that asset. So these are strategies that needs to be adopted. Again, it's a kind of lengthy topic. How do you do that? But yes, these are the things that you should be doing. So protecting your fragile assets, your friendly assets, and your personal assets are like important to understand and then start putting that into practice. So this is all that I have to share from my own side, and I am happy to hear questions and discuss these matters further. If you want to connect with me, you can connect with me on WhatsApp, or join my Facebook groups or WhatsApp groups, or you can subscribe to my YouTube channels.